A very warm welcome to everyone present here today. For today's session, we have a very special guest, Mr. Tariq Khan, who is here to speak on the topic Future of Foreign Arbitration in India. I am Palak Agarwal from Memo Pundits. I am here in the capacity of content editor and event manager. Mr. Tariq Khan is one of the most celebrated lawyers in India. Just to mention a few of his laurels, of the many, Mr. Tariq Khan is enlisted in the Foreign Legal Powerlist 2020 to 2021 as one of the top individual lawyers. He is also one of the esteemed lawyers to make it to the youngest BW Business World Legal 40 under 40 2020. He is recognized as an arbitration expert by SCC Online. He has qualified to the conference round of Judge Advocate General, Indian Army. He is skilled in various kinds of disputes, including but not limited to international and domestic arbitrations, MSME disputes, commercial, employment related, insolvency, and bankruptcy litigations. He has also represented some of the biggest domestic as well as global players in high stake project disputes pertaining to construction, supply, joint venture, oil and gas, infrastructure, renewable energy space, defective works, loss of profits, liquidated damages, prolongation, escalation, delay, indemnities, and illegal termination of contracts. He has handled arbitration under various centers, namely SIAC, Singapore International Arbitration Centre rules, ICC, International Chamber of Commerce rules, DIAC, Delhi International Arbitration Centre rules, ICA, Indian Council of Arbitration rules, etc. He has expertise in handling arbitration-related litigations like the appointment of arbitrators, injunctions, interim reliefs, removal and substitution of arbitrators, challenging of arbitral awards, and enforcement of arbitration awards in various courts of India. He is frequently invited to speak at various law conferences and events hosted by domestic bar associations, law schools, alternative dispute resolution centers, amongst other organizations. He has been teaching arbitration as a guest faculty for the past 6 years in some of the most prominent law schools of India. He has more than 50 publications to his credit in various journals, magazines, and popular legal news portals. First and foremost, I thank you, sir, for agreeing for this session with us.
Thank you.
To start with the session, sir, my first question to you is, it would be great if you could introduce our students here today with the concept of arbitration, especially foreign arbitration.
Okay, so first of all, thank you, Memo Pundits, for giving me this opportunity. And last year we started webinars. I was very active. I delivered a lot of webinars. And in the second season of COVID, which is the second lockdown, I think this is my first webinar which I'm doing. And we are all going through a very tough time. And I hope all of you are keeping safe and being productive at the same time and not just giving up on things. So it's a great discussion today because the topic which has been streamlined, it's something which has been, especially the foreign seated arbitration, the concept, it's been there for a very long time. The dispute was going on and there was no clarity on it. The issue needed clarity, which has been given by the Supreme Court recently, that whether two Indian parties can have arbitration in a foreign country. So I would like to start by telling you what is arbitration, because I think that's essential for the discussion today. I know you may all have read it quite a lot of times. In almost every judgment on arbitration, they first discuss the concept of arbitration. And many of you may be arbitration enthusiasts, so probably you would already know what it is. But just to, again, revisit the concept, the basic concept, I'd like to clarify that there are 3 or 4 pillars of arbitration. And arbitration, as you know, is an alternative dispute resolution. It's a mechanism to resolve disputes between two parties, which is outside the court, and which is the first, I think, tenet or the pillar of arbitration is party autonomy, which means freedom of parties, not freedom of a party. So two parties having the freedom to resolve the disputes the way they want, the freedom to contract, the freedom to decide on the rules and procedure, how they want their disputes to be adjudicated, where they want their disputes to be adjudicated. All of that they can do, that is party autonomy. So, which is their freedom to decide how they want to resolve their disputes. The second important feature of arbitration, I think, which should be first, is speedy resolution or disposal of disputes, which is expeditiously adjudicating disputes between parties. Because as you know that the courts are already overburdened, and the protracted litigation is something which has been discouraged for a long time because of the vacancy in the courts. There are a lot of vacancies. The judges are overburdened already. So the cases sometimes may take forever to be decided in the court of law. And that's why, I have come across cases which have been going on for generations, being filed by the forefathers, ancestors, and their grandchildren are still contesting it. So nobody would want a dispute to be adjudicated in that fashion because the money is stuck. They want the money at the end of the day, or probably a land or property. It may be a dispute relating to anything. And it is in the interest of the society that disputes must come to an end. And therefore, the law of limitation was brought in so that, people do not wait forever to file a case. And one day disputes can come to an end. Unfortunately, that is very difficult in a society like ours, where people have that nature to file cases, and mediation, for instance, is not doing that great because people like to litigate. But in any case, if two people are entering into a commercial transaction, it is their endeavor. What they want is they want that their money should be out quickly so that they can invest it in better projects, grow their money, not that their money should be stuck in the court for a long time and they are deprived of the fruits of the award, that is execution stage, once they win the matter. So that is the whole idea behind arbitration, to expeditiously resolve the dispute so that money can come out and commercial angle is there to it. That's why a lot of companies nowadays prefer having an arbitration clause rather than going to the regular protracted or monotonous litigation which used to exist earlier, which still is. But as Mr. Falias Nariman has rightly said, that the future of arbitration is bright because future of litigation is not. So that's the whole idea. The other thing is that people say that it is cost effective, it's less costly, whereas I differ. I think it's more costly sometimes. In some arbitrations, parties end up paying quite a lot of money, and that's another feature of arbitration. Arbitration, the best feature that I like the most is the fact that it is less technical than litigation. It is very flexible. If you read Section 19 of the Arbitration and Conciliation Act, it says that the parties are not bound by the strict rules of evidence. The tribunal is not bound by the strict rules of evidence and CPC, which is the Code of Civil Procedure. So the Indian Evidence Act and the Code of Civil Procedure does not apply strictly, but the principles behind the same definitely apply. So it is very flexible. So for youngsters like you, and probably somebody who's not as seasoned like me, arbitration is great because we don't know the procedures, and sometimes in civil courts, what happens is that we are appearing and the other person who's standing, he would know quite a lot about the subject, and he'd be able to probably bring some technical objection, some application that you would not know of because he's a seasoned lawyer in a court. So in district court practice, a lot of time you will see that there are some technical things which you should know. But in arbitration, I think youngsters like you, me, who are not that seasoned would still do great because there's less technicality and it's very flexible. So these are key features of arbitration which I focus, which I would like to reiterate briefly once again. Party autonomy being number one, that is freedom of parties. Second feature that I focused on is expeditious disposal of cases, which is speedy resolution of disputes, because now there's a time limit after the 2015 amendment. The time limit was introduced, which is currently 6 months for completion of the pleadings, then 1 year for resolving disputes, which is extendable by 6 more months, which makes it 6 plus 1 year plus 6 months. And if that time period gets over, then you have to go to the court under 29A to file an application and get some more time for adjudication of your disputes. Now, this is the second feature of arbitration, which I think. The third feature I like to call is, like I pointed, the flexibility and cost-effective fourth feature. That is very cost-effective. So these are like four pillars of arbitration on which they say that it's better than litigation or any other dispute resolution mechanism. Now, coming to the concept of foreign arbitrations, what are foreign treated arbitrations? Basically, arbitration is of two types. And there are two different categories to categorize this. Like first one is it can be institutional or it can be ad hoc. Ad hoc arbitration is when there is no institution involved. Parties are doing everything on their own, and it's more like a casual and very informal setup where you are making arrangements for every small little thing. You have to go to the court, like for appointment of arbitrator, for challenge to the arbitrator. All these things you are going to the court. Whereas if an institution is involved, like DIAC, ICC, SIAC, these are the institutions which are governing or providing services for arbitration. So if any institution is involved in the arbitration, then it is an institutional arbitration as opposed to ad hoc arbitration. It becomes very smooth, very flexible, and it's very convenient for the parties because the institution assume the responsibility for conducting the arbitration proceedings smoothly, and all the challenges to the arbitrator and all those miscellaneous applications, they are filed before the institution and decided by that. So you don't have to go for every small little thing to the court. The institution take care of most of the things, including appointment of arbitrator, etc. You don't have to go to the court. So that's why institutional arbitration is very important, very good. It should be encouraged. It is being encouraged now in India, and that's the reason why arbitration will develop, and that's the only way arbitration in India can prosper. If you want the arbitration culture in India, you need to encourage institutional arbitration, because almost 90% of arbitrations that we had, or more than that perhaps, were ad hoc. So that was one reason why I think arbitration was very poor in India. People discouraged going into arbitration. They said it's not really nice, it's not a good option to resolve disputes. People were upset and fed up. The other reason why people were fed up of arbitration was the unilateral appointment of arbitrators, which is a very, very major issue. That one party would reserve the right to appoint an arbitrator, and when a dispute would arise, they would appoint some of their officer who will adjudicate the disputes between the parties and be biased and give the award in favor of the party which has appointed it. So, you don't bite the hands that feed you. So if you're being given the appointment by somebody, you will never pass a judgment against that person. So that was a very good move by Supreme Court, wherein they said that unilateral appointment will be not be allowed anymore. That was the much needed for arbitration, because people were really not liking this thing about arbitration, that a party would, which was in a dominant position while executing the contract, will reserve the right to appoint arbitrator and later on appoint their own person, and then award will be against you because the other party has appointed, so he will obviously favor them. But after the judgment of TRF, slightly clarity was given, but there was still an issue. Then an important judgment came in Perkins Eastman, which is a very important judgment which all of you should know. Perkins Eastman versus HSCC. This was a judgment by Justice UU Lalit, Justice Uday Umesh Lalit, and Justice Indu Malhotra, wherein they said that when a party is interested in a dispute, then he or she must not have the right to appoint a sole arbitrator. So that, I think, put an end to the unilateral appointment of arbitrators, which was excellent move by the Supreme Court, the best judgment which I find, because it has helped the cause of arbitration. Now, moving forward, I have told you institutional and ad hoc arbitration. Now, the other thing which you should know is that arbitration can be divided into a domestic arbitration and a foreign arbitration, which is international commercial arbitration. So domestic arbitration and international commercial arbitration. Now, if you read section 2, you will see the definition of international commercial arbitration as an arbitration in which one foreign party is involved. Now, one foreign party or one foreign element, a company is foreign company, like, a dispute between an Indian company and a British company, or an Indian company or a company based in Ireland. Now, this is an international commercial arbitration. The only thing you have to see is that this one of the parties is a foreign element. Domestic arbitration is when two parties are Indian parties. For instance, if there is a dispute between me and Mr. Deepak Lad, who's attending this show, he's my senior. And so if there's a dispute between two Indian parties, then it is obviously going to be a domestic arbitration. It's not an international commercial arbitration. So that's a simple way of deciding what is international commercial arbitration and what is a domestic arbitration. Now, suppose there is a issue which was there in one of the matters. I think it was in Perkins Eastman only. I think I don't recall, but I think this is the correct recollection. There was an issue whether Section 11, which was filed in Supreme Court for appointment of arbitrator, whether it was right, because you should clearly know this, that an application for appointment of an arbitrator can only be filed in the High Court. But if there is an international commercial arbitration, then you have to go directly to the Supreme Court to file an application for appointment of arbitration under Section 11. So I think there was an objection taken in that judgment, in that case, that this is not where the Section 11 application should lie. It should have gone to the High Court. So the issue was whether the application was correctly filed or not. Was it maintainable? Because the objection was that the parties are Indian party and there's no foreign element. Then the court, I think, looked into this aspect, and there was a consortium. You know, consortium is when two companies come together and form a consortium. So there was a foreign element in the consortium, and there was an Indian element, Indian company. Now the court said that because the majority percentage is of the foreign element, then that is enough, to make it an international commercial arbitration. And that's how they said that it will be treated as an international commercial arbitration. So this was the interesting thing which the Supreme Court held. So always remember that in case there is any dispute insofar as whether an arbitration is an international commercial arbitration or not, you need to ascertain as to whether there is a foreign element present in the arbitration or not. If it is, then definitely it will be a international commercial arbitration. And if it is a domestic, two parties which are only based in India, then it is a domestic arbitration. So I think I've answered your question. I'm sorry, I think I exceeded. I didn't give this question too much time. Yeah, so you can move to the next question now.
Yes, definitely, sir. So my next question to you is, what is meant by the autonomy of Indian parties to choose foreign seats for arbitration? If you could
Okay,
explain.
so yeah. So this was explained. I'm sure your next question will be based on the recent judgment of the Supreme Court, but I'll clarify that in this. So recently, for the longest time, this issue was there because on one hand, we said that arbitration permits parties to do whatever they want, like, party autonomy. Party autonomy means that parties are free to decide on what they want to do, how they want to adjudicate the disputes, freedom of parties. Now, imagine two parties, if they want that we want to settle, like two Indian parties, like I said, me and Mr. Deepak Lad, if we want to settle our disputes not in India, we want to go and do this arbitration in London, which is a neutral venue or neutral seat, neutral place, then can it be allowed? Because the problem is we are going away from the substantive law of the country. And then would this not be against the public policy of the country? That two Indian parties, there is no foreign element, and you still want to go and resolve your disputes in London or Dubai or Malaysia, why can't you do it in India? So this was the issue always, that can two Indian parties be allowed? Now the objection was that, look, there is no foreign element, so you can't go to a foreign land. Second objection was that substantive law of the country will apply. You can't do away with it because you're an Indian, you're bound by it. It's public policy. That was the third objection. The concern was public policy, that if two Indian parties are not resolving the disputes as per the substantive law of India, then it is against the public policy. On the contrary, the only argument which was there in favor of two Indian parties who wanted to go with a foreign seat or foreign country as a venue, a neutral place to adjudicate the disputes, it was party autonomy. That parties are free to do what they want. Let them go and decide their disputes. How are you affected? Now, the recent judgment, Justice Nariman has very rightly discussed the law on the point. It is a very interesting judgment. You would like to share the citation, if you can, with all of the people who are present here. If it is in your next question, you can do it. In the chat box, you can perhaps write the name of the judgment and the citation so that they can read for themselves. Now,
Sure, sir.
the thing is that basically, I'll just tell you the gist of the matter. What the Supreme Court has finally held is, Supreme Court has upheld the decision of the Gujarat High Court. Gujarat High Court had held that so PASL Wind Solution versus GE Power Conversion, India Private Limited, that has been shared in the chat box. The Gujarat High Court had held that two Indian parties can go for a foreign seat of arbitration. This was challenged in the Supreme Court. Now, the Supreme Court has said that freedom to contract you cannot take away from a party. And the court discussed about Section 28 of the Contract Act. Then Section 23 was discussed. Section 2 of the Arbitration Act was discussed. These are like relevant provisions which you would also want to have a look at once you read the judgment. The court held that, look, party autonomy is the brooding spirit. It's the key of arbitration. If you can, not give emphasis to this, then there is nothing which remains. So what Supreme Court did, Supreme Court relied on a lot of foreign commentaries, Indian commentaries, including Justice Indu Malhotra's commentary on the arbitration. And excerpts were quoted that these are the fundamental principles, the pillars of arbitration, including party autonomy. So all those judgments like Balco was quoted, Sasan Power was quoted, Renu Sagar, all of those judgments were quoted. And Supreme Court essentially said that, look, because parties are free to be on a, to freedom to contract is very essential. Now let's compare it with public policy. Then Supreme Court also emphasized that how public policy keeps changing from time to time. Things which were not permissible earlier are now allowed because public policy does not remain same. It keeps changing with time. So these were the factors which were discussed. And Supreme Court then said that, look, because there is nothing in allowing two Indian parties to choose a foreign arbitration seat of arbitration or foreign law of arbitration to adjudicate the disputes in a foreign venue, then we don't think it's affecting public policy in any way. There's nothing which shows till date that it is going to harm the public in general if we allow this. And I think we should protect the party autonomy principle and we should encourage it because that is the spirit of arbitration. So with this logic, the Supreme Court said it is allowed. Two Indian parties can go to a foreign venue to conduct arbitration. They can do it there. Nobody can stop them. And interesting thing is that Supreme Court said that yes, what can happen is that when an award will come, it will not be a domestic award, it will be a foreign award. And when a foreign award will come to India, then you can challenge it under 48. The enforcement principles will apply. It will not be, part one will not be applicable, and part two will be applicable on the award. And you can take all those objections that you want regarding public policy, etc. at that stage. That will always be open. But the court also clarified that Section 9 will be maintainable because there was another decision. In the same decision, the Gujarat High Court said that Section 9 will not be maintainable. So that part of the finding of the Gujarat High Court was overruled by the Supreme Court. The Supreme Court said no, Section 9 will be applicable. Because if you will remember the story of Section 9, or even if you don't know, I'll just tell you quickly. In the first judgment, which was a landmark judgment in India, was Bhatia. Now, Bhatia judgment said that part one will apply to part two, which means that even in foreign seated arbitrations, part one will be applicable in entirety. So this was criticized worldwide. People said that how the Indian courts want to control arbitrations and they want to apply the law, the part one, which is like Section 9, Section 11, all these things will be applicable, then what remains? Because in all foreign arbitrations, Indian courts will be interfering, the judiciary will be interfering. Then came Balco, which said part one will not be applicable in part two, which means that in foreign arbitrations, part one will not be applicable of the Arbitration Act. Again, there was an issue that, look, there are some measures which Indian parties may need, but because part one is not applicable, Section 9 will not be there. Then Section 2.2 of the Amendment Act of 2015, if you read, Section 9, Section 27, and 37.318. These three provisions were allowed even in part two. So part one per se is not applicable except Section 9, 27, which is court's assistance in taking evidence. Section 9 is the interim measures by the court, and Section 37.318, which is the these three provisions were allowed to be applied even in foreign arbitration. By that logic, the court said, I think we need to unmute someone. Somebody is Okay, thanks. So section 37(3)(1)(a), these three provisions I said were to be applied, even though they are in part 1 of the Arbitration Act, but they're still applicable to foreign seated arbitrations. So the issue regarding filing of a section 9 in such arbitrations, the court says it will be available to the parties. They can always file a section 9, even if it is a foreign seated arbitration. So this was the reasoning that the court gave. And now, as the law stands, two Indian parties can choose a foreign land for adjudicating their disputes.
Thank you very much, sir. I just have a very small follow-up question to your
Yeah.
explanation. That you said that part 1 is not applicable in entirety, but only some sections, that is, for example, section 9 and section 27. So my question is that are these sections, can parties take aid from these sections if they want to, as a matter of choice, or they are compulsorily applicable?
So if you read the language of, I think section 2.2 clearly says that parties can do away with it, because I think it starts with the language, unless otherwise agreed by the parties. Now, this is very crucial. I think if you pay attention, you will realize that many of the provisions in the Indian Arbitration Act, they start with the three letters, unless otherwise agreed by the parties. That's more than 3 words, sorry, 5 words, which means that if parties want, they can do away with this provision. So, it's a derogable or non-derogable provisions. So if parties specifically in their contract write that these sections will not apply to our dispute, then you cannot say later on that, look, I want to rely on these. So it is completely the discretion of the parties. If they specifically write in their agreement that these provisions will not be applicable, then they will not be available, even though the statute says so.
All right, sir. Thank you very much. My next question to you is that what is the scope of judicial intervention in foreign seated arbitrations in India? Part of it has already been explained by you through the analysis of various judgment. The second prong of this question for you would be that, for instance, there is an arbitration where the seat is in England, and stated that already stated that some part of the Indian law would also or may be applicable if the parties choose so. So wouldn't that be in contradiction with respect to the seat that the parties have chosen for themselves?
See, I understand this. The concept of seat is often misunderstood by a lot of people, and I've seen that people still have not got clarity what is the seat. So let's understand seat, venue, or place. These are three terms. Seat has
Indeed, sir.
nowhere been defined in the Arbitration Act. That at one place, I think place or venue has been used in section 20 or somewhere, if you will read. Now, the court has very simply clarified, if you read BGS Soma judgment of the Justice Nariman, what they have said is that, and even in the judgment of Mankatsu Impex, which was our last year by Justice Banumati, the law is simple, that if the seat of arbitration is at a particular place, only that place will be the epicenter of arbitration, and only the courts of that place shall have the jurisdiction, no other place. So if the seat is Delhi, courts of Delhi alone shall have jurisdiction. Second, if the term seat has not been used, if you have used place or venue, then unless there is something expressly or significantly indicating otherwise, then the venue or place will be treated as seat. This is the current position of the law. Earlier, Hardy said something else. Hardy was overruled in a way which cannot be done by equivalent bench. But Hardy said, Hardy exploration case, that when if there is a party which is parties have mentioned place or venue, and if there'll be additional concomitant factors in support of the seat like cause of action, etc., then you can treat place as a seat of arbitration. So place plus other factors, concomitant factors, is equal to seat. But Hardy's logic was defied by the Supreme Court again, Justice Nariman. BJ Soma says, which is the later judgment, that Hardy is incorrect because the reliance on Balco is misplaced, and it is not correctly quoting Balco and Roger Soshua case also, the test. What currently the law is that if the place or venue is defined, it will be treated as seat unless there is something significantly which is contrary to that, which is showing that it cannot be the seat. So this is the current position. So seat determines everything. I'll give you an example of Mankatsu Impact's judgment. What happened was somebody moved to Supreme Court for appointment of an arbitrator. Justice Bhanumati said, look, the seat of arbitration is in Hong Kong. You cannot file an application here. Go to Hong Kong, file the application there, because that is the seat. So clarity so far as seat is concerned, I think I have given you. The courts of seat alone shall have jurisdiction. If there's any issue in your mind regarding which court to go, only stick to the seat court, nothing else. That's clear. The second is the future of, you were asking about how it will happen now. Two parties are being permitted to file, to go take their case and get it adjudicated in a foreign land. I think that's a positive step. Encouraging party autonomy is obviously a very positive step. I think it will have an impact on cross-border, arbitration. Like, you will in fact see many people doing that. But I frankly don't think it will have bearing. And why would two Indian parties want to adjudicate the disputes in a foreign land? Maybe that, some party which is in India, which is having a very some kind of control, and there is some feeling of another party which is not very confident about the arbitration being conducted in India. For its own security, it may have its own notions regarding impartiality, independence. It may want to take it to a foreign land, or the dispute may be such wherein they expect quality of arbitrators or the institution to be better than that which is there in India. These may be some reasons why parties would want to choose that. That fear may be there, but honestly, I don't see two Indian parties going to a foreign land. Like, what is the point? You can resolve your disputes here. We have good arbitrators. We have everything which is required to adjudicate disputes worth millions and billions of dollars. So yeah, I think, but it's a positive step, to be honest.
Indeed, sir. I have a follow-up question in the chat box from Saurabh. He says that in case of conflict between the seat of arbitration and chosen institutional rules, what would supersede?
Okay, so understand this. Firstly, that when you're choosing an institution, a lot of people have this issue. They think that if they're choosing SIAC as an institution, so law of Singapore will not apply. Singapore, only the SIAC rules are applicable. It has nothing to do with the courts of Singapore, or the seat of Singapore will not be the seat merely because you have chosen SIAC as the rules, SIAC rules. This is only governing the arbitration procedure. The conduct of arbitral proceedings is being managed by the rules. And if there is a conflict between the rules and the act, then you will have to see whether the terms of the law is starting from unless otherwise agreed by the parties. So if it is starting like that, then rules will apply. Otherwise, the law will apply. The rules cannot be in derogation with the law unless the law itself starts with unless otherwise agreed by the parties. Because rules parties are agreeing to. So parties cannot they have to stick to the rules of the institution, unless the rule is contrary to the main law, like the law of arbitration. I'll give an example. I think it would be better if I explain it with an example. Sometimes what happens is, if we go by DIAC rules, Delhi International Arbitration Centre rules, DIAC has its own rules. Parties say that we want DIAC to conduct the proceedings under the aegis of DIAC. Now, DIAC rules are applicable. You cannot do away. You cannot say, no, I don't want to follow this rule. Now you have accepted, you have to stick to the rules. Assuming that there is a rule which is against the Indian Arbitration Act, and now you open that section, and if you see that the first words of that section are provisions are derogable or non-derogable. If it is something which says unless otherwise agreed by the parties, which means that it is derogable, you can do away with it. It is permissible as per the law, and you have done it. You have chosen the IC rules, then rules will apply. But if it is something which does not start like that, then in case of a conflict, Indian Arbitration Act will apply. So that's how you determine it.
Very well, sir. Another question that is there in the chat box says that if one of the parties is not from India, then still the Indian court will have the jurisdiction or not? And what if the seat is in India?
Okay, if the seat is in India, then there is no question of any other court. Of course, Indian courts. If it's in Delhi, the courts in Delhi alone shall have jurisdiction. Then there's no matter who's the party. If India is the seat, then Indian courts will have jurisdiction. Now, coming to the first question, wherein you said that what if there is a foreign party? Will Indian courts still have jurisdiction? The answer is yes. For instance, in case of Section 9, like I said, even if it's a foreign seated arbitration, Section 9 is always applicable unless parties specifically do away with it. So Indian courts will definitely have a jurisdiction. Now take example of enforcement. If the foreign party wins the arbitration, how will they recover? The recovery is to be done in the Indian courts. They have to enforce the Indian awards because the assets will be located in India. And if the assets are located in India, you have to come to India to enforce the award. And for that, there'll be recognition of the award and enforcement, which is 48, 49. So yeah, 48 tests will have to be there. So you'll have to come to the Indian courts. That's the bottom line.
So there's a follow-up question that what if both of the parties are not from India, but the seat is in India?
Like I said, if the seat is in India, you have to come to India because you have chosen India as the seat. So Indian courts will have jurisdiction for every small little thing. You'll have to come to India. Seat
Indeed,
is the
sir.
key. You only have to look if seat is there, then the local courts of the seat have the jurisdiction.
Sir, I have another question. That is, for example, both of the parties are Indian, but the seat that they have designated is, say, of another country, for example, Hong Kong. But since the parties are Indian, they would have to definitely conform with the Indian laws, because in that case, otherwise the award would not be enforceable. So, can we say that seat is in a way affected or influenced by the nationality of the parties, or in this example, Indian laws, for example, Section 9 or Section 27, which
I
are
don't
anyway
think so.
applicable?
I mean, my understanding is that it is not. Parties, like what the judgment has clarified, that even if two Indian parties are there and if they're choosing a neutral seat of arbitration, so I think they'll have to go to the court irrespective of their nationality. It is because they're choosing it voluntarily with open eyes. Tomorrow they cannot say, oh, I was not conscious about the laws of this country. Why did I go for it? So you apply your brain, be diligent, and once you go for it, I think something like that was discussed in Balco also, and even in Reliance versus UOI, I think. In this, the Justice Nariman had opined that parties have to be diligent and careful when they're going for a seat. Later on, they can't say, oh, we did not know the law of the seat was not proper. So they have to be very careful when they are choosing a seat of arbitration and accordingly take a call.
Indeed, sir. So,
Yeah.
sir, is your stance the same even if there is a conflicting or apparent error which the parties would know at the time of dispute, that this particular error would have a public policy issue in at the time of enforcement in India?
Yes,
So,
if there is a public policy issue, then it will not be enforced. That of course defense will always be there. So as long as it is not against that, you have to read dicey on this, because the judgment, if you will read it, is very interesting because excerpts have been quoted. Conflict of laws and how which will prevail, that has been discussed by Justice Nariman at length in this judgment. Obviously, something which is in the moment you are able to show that it is not in committee of courts, it's not there, it's not as per the public policy of India, it is clearly violating the public policy. But please understand that the test of 34 will not be there in that case, because patent illegality, for instance, is a ground to set aside a domestic award under 34, whereas this ground is not available for a foreign award. So you cannot get a foreign award set aside on the ground that it is patently illegal. So that ground will vanish. That ground will go. So the challenge will be difficult, because when a foreign award is being dealt with in India by the Indian courts, the scope is much more narrow than a domestic award to
indeed,
set it
sir.
aside. So that is to be
Indeed,
kept
sir.
in mind, of course. But if public policy obviously is the ground for not enforcing the award.
Indeed, sir. Section 48 would be applicable in that sense.
Yes.
Definitely, sir. So, I have a lot of questions in the chat box. I would refrain for a while for those and continue with the interview, and
Yeah.
then we
Try
can take
to
the.
try to cover the questions in the questions, because I think we have only 20 minutes left, and I would like to finish in time, and I would like to.
Definitely, sir.
Yeah.
So, my next question to you is that what is the modern law approach towards the foreign seated arbitration in India, considering that we have already discussed the most recent judgment? What is your stance on it?
I think a lot of foreign countries do permit it. Like they do not have any issues. I think India was one country which was refraining for the longest time in allowing its citizens or parties to go for a foreign seated arbitration. I think if you want to promote yourself as a arbitration-friendly jurisdiction. And as a jurisdiction which wants to become the hub of arbitration, then you need to, set such precedents. The courts must come up with such judgments to show that, look, we are evolving and we are doing away with the traditional approach. We are very open. We want to become a hub of arbitration. And, we are promoting arbitration culture in India. We are promoting cross-border culture. We want these arbitrations to go to foreign countries also. You also send arbitrations to our country, like that. So I think it's a very positive approach, and it's in the interest of arbitration. And this will eventually give a very positive message where Indian courts are arbitration friendly and they are encouraging arbitration. So yeah, India's dream of becoming a hub of arbitration, I think all of this will come, definitely.
Indeed, sir. So my next question to you is, what can a law student do at these nascent years if they want to pursue a career in arbitration law?
So right now, law students are really worried. Right now, I don't know what they are doing. But honestly, I need to give a message to law students because I think that's my favorite thing to do, because I like giving all these advice because I can understand their issues, their pain. So, firstly, I'd like to tell you all that imagine the students who graduated last year, and a lot of them till now do not have a job because they're having a very tough time. They were very unfortunate that they graduated at a time when the market was really in a bad shape. There were no jobs, and salaries were being cut. People were being fired. So there were no opportunities. And then when situation started getting, better, again, we have a new lockdown and some more fresh graduates. The industry does not have the capacity to satisfy those demands. But again, like I'll say that, you are not alone in this. And I know that all of you are having a very tough time. It looks very bad. Situation seems like there's a dead end in life. The career is, the beginning is so bad because you worked very hard all of your 5 years and you have a lot of expectations. But please understand that we are all in this together. You may look at me and feel that, oh, this person is doing fine and all. No, we all have been affected, no matter how senior, how junior, each and every one of us is affected. Right now, your focus should be your health and not your job. Believe me, stay safe, stay home. And yes, the learning should not stop. Grow yourself, identify your area of interest, do not stop applying. All of that is crucial, all of that is important. Situation will normalize. 1 year will not make any difference in your career. You will have a very, very long and flourishing career, all of you. So stay positive. And arbitration, yes, it's a very good field for all of you. What you can do is, in the meantime, even if you're not getting a job, money is not everything. Learning is important. And in fact, the money you will get initially will be peanuts. So whether you get it or you don't get it, it is okay. But your learning should not stop. And you need to start reading judgments on a daily basis. Read one judgment at least a day. Arbitration has a very, very bright future, I feel. And all of you can do excellent. Like I said, it is less technical, very flexible. So all of you who do not come from family of lawyers will have a great advantage over the other. It's a very recent concept. So a lot of people who are, you know, like seasoned lawyers, like with 4 decades, 5 decades experience, you will have an advantage because the new concepts are coming up. So, try to develop a niche in some specific kind of arbitration. Like, for instance, sports arbitration. I don't see many great lawyers in sports arbitration right now. You can be that person. When I started doing arbitration, I think I was one of the first few people doing it. Like, it was always popular, not that 1940, and even before that we had arbitrations, but it became gained that kind of popularity in the past 10 years, I feel. So I would say that I was lucky that I got into arbitration in the right time, and I've been doing it since day one. So look at the modern day approach, like BITs, maritime arbitration. Right now they may not have any name here, construction arbitrations, but in times to come, I'm telling you, they will flourish. They'll have a very bright future. So you get in it right in the time and keep changing your approach as per the needs of the society. Like, if, okay, merely because I'm doing arbitration or others are doing arbitration and you see them as somebody who are doing great, that should not be the criteria for choosing arbitration as a career. Truth is not always appearance. So do not think of it as the ultimate thing. If you are interested and passionate about something else, pursue that, because you may not succeed in anything if you are not honestly into it. If you do not, it's innate, the interest. It develops with time. Yes, I agree. But if you are just doing it because others are doing it and everybody is doing arbitration, that should not be the motive. Motive should be that you honestly like the idea, you believe in it, you're passionate about it. That is only should be the reason why you want to pursue arbitration as a career. So yeah, that's my only advice to all of you.
I think that is a very wise advice, sir. And I believe that Justice Romana has set an example for all of us by being the first generation lawyer and making it to the esteemed office of the Chief Justice of India.
Yeah, he's the
And
first, but I'm sure there'll be many others now on.
indeed, sir. Indeed, sir. So, sir, a broader question that I wanted to ask you was that as a current law student, a third year or a fourth year student, are there any books, are there any peer reviewed articles, or any other source that we as students should refer to in order to start in the field of arbitration?
Excellent. So I think that you should read my articles. I'd like to advertise myself first. I keep writing quite a lot on arbitration, but I think you
Indeed.
should start writing. You first read from the books. I'll tell you some books which you can read if you are interested in arbitration. I think the best book currently which I have seen is the book by Justice Indu Malhotra. It's amazing, but it's slightly expensive for a student, I feel, and that's why I'm coming with the idea of coming up with a book for students, which is not that expensive. I'm planning to come up with a book on my own because the whole idea is that students should be not be deprived of quality merely because the prices are high. So student-friendly books. But if you talk about good books, if your library has it, Justice Sindhu Malhotra's book is really, really nice. Then if you want to read about foreign arbitrations, international arbitration, then I think the good book that you can refer to is by none other than Martin Hunter and Alan Redfern. Redfern and Hunter, that's the Bible of arbitration. So they have a
Indeed, sir.
book which you can read, and I think for foreign arbitration, it's a wonderful book to read. I read from it. But more than that, I think as a student, if you don't want to buy that and if you don't want to start, because I know reading gets boring sometimes, even I find it boring and a lot of times. So you can read articles on Mondac, you can read articles on Bar and Bench, Live Law, iPleaders, SCC Online. They have some great stuff. And you should, in fact, start writing, like, RGNUL, for instance, has a very good journal, RMFLR. Then they have other journals also, ADR journal. So they are doing a lot of work. So you can, in fact, see on their page or probably get in touch with them. You should write, encourage yourself to write, because when you write on a particular topic, you will read a lot about it. Like today, if I tell you write on foreign seated arbitration, two Indian parties going for a foreign seated arbitration, you will have to read everything on this to be able to write something on it. So writing is the key to learn, because when you have to write a 10-page document, you have to reach at least 100 or 1,000 pages. Only then you'll be able to do justice, unless you want to do a plagiarize and copy paste work. So reading is necessary for writing. So start with writing, and all of you should write. Imagine that these people will not publish your paper. I'm assuming the worst, which a lot of people did not do initially when I started. I started writing on my own LinkedIn page. I made it my blog. And initially I got like 1 like, 2 like, 3 likes, 4 likes, but it increased with time. No, Rome was not built in a day. So stay positive and keep writing. If your work is nice, everybody will notice. And honestly, if I come across something interesting, I will share it on my LinkedIn page. So you all be in touch, stay in touch with each other, help each other. We are there for each other, but do not lose hope. Stay positive, keep reading, keep writing.